Vastola.
Well, good morning, everybody, and thank you so much for tuning in to another edition of Vastola on the Law. I am Jeff Vastola, your host, and I am here almost every Saturday morning live to give you free legal advice. So all you have to do is call into the show to get some customized personal legal advice to whatever your issue may be. You just heard the number. It's 877-850-8585. That will get you live into the studio with Dan, my board operator. Good morning, Dan. He will take some basic information from you. He'll put you live on the air with me, and you can ask me anything that you want. If I can answer your question here and now, that's exactly what I will do. If I need to take some time to do the research so that I give you a good answer, what I consider to be an educated response to your question, then that's exactly what I will do, and I will get back to you the following week with that answer. If you're not able to listen to the following week's program, no big deal. We have a library of every single show that we've ever done. You can access that library through my website, which is vastolalegal.com. My last name is spelled V as in Victor, Astola. And you can go to my website to find out not just prior shows, but all about me and my law firm, vastolalegal.com. You can also access the library of shows by going to the 8:50 AM website, which is, of course, the radio show that I am on live every Saturday morning, and access all of our podcasts from there as well. Now, there is information on our website about myself personally, my family. There's our YouTube station is accessible from there as well. We do have a YouTube station where all of these, that's another place, I guess, where you can access all of these prior shows, is on YouTube. Uncle Jeff, good morning. Nice to see you. Hope things are great. And very, very sorry we missed the wedding in California. Those pictures were amazing. Congratulations to my cousin David, who got married out in California, to his very beautiful bride. And I'm very sorry we couldn't make that. But anyway, my website has more information about us and our accomplishments over the years. This coming October, will be an attorney. I believe it's going on 26 years, being in business for myself for, I think, 25 years this year. It's either 24 or 25. I'll have to do the math off the air because I can't do that math that quickly in my head. Now, I always like to be a resource for people, which is why I'm here live every Saturday morning, so I can answer your questions. Of course, I do have topics planned, so I'll have things to talk about over the next 30 minutes in case nobody calls in. But I like to be a resource for people, and I like to be immediately accessible. And the way I do that is I give you my cell phone number. It's 833-VASTOLA. That's a toll-free number. It forwards to my cell phone all the time. So if you dial 833-VASTOLA, which is 833-827-8652. That will get you right to my cell phone. Sometimes I answer when I'm available. I do answer my phone. Sometimes I'm not available to answer the phone, but if you leave me a message, I will get back to you. I did receive a message after last week's program from a lovely woman who gave me a very lengthy story about her homeowners association and coconut trees and coconuts that were overgrown, and the coconuts were not being trimmed. And so my response to that phone call was a text message to say, hey, that is a great topic for the radio show. So please call me next week and let's have a live conversation about your concern about the overgrown coconut trees and how the HOA is not trimming them appropriately. There are issues of safety involved. You know, look, if you get hit in the head from a coconut that falls from a tree, there are some people that say that could kill you. So it's a safety issue and it needs to be discussed. But I thought to myself, why have a private conversation about overgrown coconut trees when this is something we can talk to everybody about on the program? So hopefully she'll call in with her question and her concerns about the overgrown coconuts. Today, I'm going to be talking about domestic violence. I don't know why I'm on this, I don't want to call it a kick, but this topic of domestic violence. They show up a lot in my Florida Law Weekly, which is a weekly publication of Florida law. They are new opinions published by the various district courts of appeal, as well as the Florida Supreme Court. And these are, when these opinions are published, they become law. They are what we call stare decisis. There's different variations of law. You find law in the statutes, you find law in various codes, and you also have these opinions from these higher level courts that have come down over the years called stare decisis, which is a very broad area of what we call the common law. And every week the courts are pushing out new opinions, and so every single week we get new law in the state of Florida. Sometimes these opinions are simply confirming existing law, saying yes, the law still stands, the law still stands. Every once in a while we'll get a Florida Supreme Court opinion, which of course is the law of our land here in Florida, that will change the law. We'll reverse a prior opinion, or we'll create new law. And so we always are on the lookout for what the law may be on any given day, any given week, any given month. As lawyers, it's our obligation to stay up on the law, which is why I try to read these every week. But I've come up with a topic that has to do with, again, injunctions for domestic violence. And it's not because of another case that came up in this journal, this publication that I get, but because of a specific request from a person that contacted me to talk about it. And so I've decided to make the issues of where you file for domestic violence my topic for today, which I'll get into in just a moment. And then also Florida's Longarm statute. Florida's Longarm statute is the statute that delineates how and when a Florida resident can sue a non-resident of the state of Florida in the state of Florida, so that the Florida courts have jurisdiction over that non-resident. Because if there are no bases, what we call minimum contacts with the state of Florida, if you were to sue somebody who lives in Ohio, for example, or some other state other than Florida, just because of convenience, because that's where you wanted to file the lawsuit and for no other reason, when that person receives notice of the lawsuit, the first thing that he or she is likely going to do, especially if they hire an attorney, is they're going to say, hey, Florida, you have no jurisdiction over me. You can't decide this. You have no right to determine my rights and my responsibilities because I've never been to Florida. I have no minimum contacts. The Florida Longarm statute is what establishes what these minimum contacts may be. And there's essentially 9 different ways that a Florida court can exercise jurisdiction over a non-resident of the state of Florida, depending on what the circumstances may be. Some of them are quite limited to certain areas, but I'm going to go over those so that you may have a better understanding of that. That's called minimum contacts. And then lastly, if I have time, I wanted to talk about, I'm going to go back to this case of Young versus Love. I brought it up at the very end of my show last week, and I was so jammed up for time, I didn't really I didn't afford myself the time to go into a lot of detail. And what's concerning to me about this case is not the majority's opinion. I think the majority got it right. What happens when appellate courts are making determinations is that it's typically a panel of judges. And sometimes they all agree, but not very often. And if they don't all agree, then it's majority wins. Whoever, whatever the majority opinion is, that's what is the prevailing opinion, and that's what's published as the given law. But sometimes the judges that are in the minority of the given opinion don't go away quietly, and they write what's called a dissenting opinion. And the dissenting opinion in this case of Young versus Love is incredibly concerning to me, just based on my own personal beliefs and the way things ought to be in my mind. So I wanted to spend a little bit more time talking about Young versus Love. And if anybody's interested, if we have any scholars out there and you're wanting to find it, it would be cited as, let me see, it probably doesn't have yet a full-blown third opinion. Okay, case ID number. It's out of the 1st District, which is up there in Tallahassee area. Case number is 1 D as in David 18-2844. So you can look that up going to Florida Law Weekly with that identification number and probably find it. And of course, if you can't find it and you want a copy of it, just let me know, and I'll be happy to send you a copy of what I see here. For those of you that are not aware, we of course had that tragedy a couple of weeks ago, the Miami building collapse. Lawsuits were immediately filed, as you can imagine. That's in this day and age, that's what happens. And a Miami judge has already made a ruling that at an absolute minimum, those affected by that building collapse down in Miami will have access to at least $150 million for purposes of compensation. Now, what concerns me immediately is, first of all, the venue and the amount of fraud that's going to be perpetuated down there. It's just very unfortunate. We know from many prior cases having to do with personal injury protection benefits and everything else that there are a lot of fraudsters down in South Florida. They find ways to collect money that doesn't genuinely belong to them. And so I'm hoping, and I'm certain that the courts will do a good job of vetting legitimate cases from those that are not, but be on the lookout for some claims of fraud, because just the extraordinary amount of money that's becoming accessible to the victims of the building collapse. And so what are victims? That's, again, probably fertile ground for people to start making fraudulent claims. Oh, well, you know, I was down the street and it caused me mental anguish because I saw it. You know, who knows, maybe that's legitimate. But anyway, I just wanted to share that bit of news because it just came out the other day. Keep in mind that this $150 million is not the limit of monies that will be available to anybody affected, any victims of the building collapse. That's the absolute minimum. And the judge, in his opinion, actually made it clear that this was not all of the monies that may be available. Basically, the $150 million is coming from $50 million in insurance coverage, and then $100 million from the sale of the building, which has either already happened or is contemplated to happen. So if you've been affected by that, be aware you have rights. If you have not been affected by that, please don't make a claim. All right, so if you are a victim of domestic violence, this is really my topic for today. Where do you file for what's called an injunction? You know, if you have a stalker and you want to get one of these orders that prevents this person from coming within a certain distance of you, what you're technically asking the judge to award is what's called an injunction. And the injunction is a noun. That's the remedy that the court will provide if you prevail. But there's a verb form of the word injunction, and that is to enjoin. Now, injunction is spelled I-N-J-U-N-C-T-I-O-N. The verb form of the word enjoin is E-N-J-O-I-N. So you can enjoin somebody, a verb, to not do something anymore that they have been doing. That's typically what you see in a stalking context. You say, hey, stop coming around my house. Stop being a stalker. I'm going to enjoin you from coming within a certain distance of me or my home. You can also enjoin somebody to do something that they're legally obligated to do, but that they're not doing. So keep in mind that the remedy of an injunction is not always just in the context of a domestic violence stay away order. It can be a remedy used if you have, for example, a contract and somebody is supposed to be doing something and they're not doing it. You can seek the remedy of an injunction to enjoin somebody to do something that they're not doing. So, good morning, Moses. Hopefully we'll see you tomorrow. I don't know if you're in town or not. My friend Moses and I play soccer most Sunday mornings. So, again, domestic violence. The question that came to me this week was, I've been the victim of domestic violence with what was, you know, my partner, and because I think they weren't married, and it happened in several different states just because of the nature of the good morning, Moses. The occupation of the other person involved caused that person to be in several states for his occupation, and she would accompany him in several different states, and the violence, the physical abuse, was occurring in several different states. And so the question was, where do I file this? What is a lawsuit essentially? Where do I file to get the injunction? the domestic order so that he can't come around or within a certain distance. Well, come to find out, and this is not unusual, most states cooperate with one another in the context of a legitimate claim of abuse. You can file for the injunction in any given state where it happened, and most of the other states in the Union, our United States, will acknowledge that order and enforce that injunction even if it was not rendered in that state. So really, if you're involved in a situation like that, if you've been abused in several different states, then you could choose essentially where you wanted to file for the injunction. And then you would probably have to, if, for example, you were going to go to another state and you wanted that new state to enforce the injunction that you had been awarded in another state, you'd probably have to domicile the injunction. You'd probably have to file it in the new state somewhere just to make sure the new state was aware of it and would enforce it. But if anybody's interested in what are the states that acknowledge a domestic violence injunction that was entered in some other state, I can certainly pull that up for you because I had that website up earlier this morning as I was doing some research. But that really wasn't the focus of the topic. The topic was, okay, where can you file it? You can file it basically in any of the states where it occurred, and you can also file it in a state where that given state would have jurisdiction over the defendant. So, for example, if the abuse happened in several different states around the country, but the defendant lives in California, you can file it in California. Even if there was no abuse in California, you can file it in California because that's where he lives. And you can present to a California court all the different instances of abuse throughout the country, and presumably, if the claim has merit, then the California court would enter that injunction. So, in the event, though, that you're contemplating filing the lawsuit in your home state simply for purposes of convenience, and you're wondering, is the Florida court going to have jurisdiction over this person or this company, now going beyond just a domestic violence kind of a concept, will a Florida court have jurisdiction over the defendant that I plan to sue? That's the topic of minimum contacts, and that brings in the Florida Longarm statute, and Florida's Longarm statute is Florida statute, forgive me while I squint, I'm trying to see this on my screen, 48.193. That's Florida's Longarm statute. And again, if you're just now tuning in, if you didn't hear what I said earlier, Florida's Longarm statute is the statute that explains how and when the state of Florida will have jurisdiction over a non-resident. And section 1A of this section that I just mentioned, 48.193, enumerates essentially 9 different ways that the Florida court will have jurisdiction over a defendant that doesn't live here. And so let me just kind of run through them, expound on them if necessary, but more importantly, let me give out the number because I have been imploring some folks to call into the show this morning. If you'd like to call into the show with a question of your own, or a topic of your own, topics are fine too. I'm happy to bring up a topic and have a discussion. 877-850-8585. That's the number to call into the show. Board operator Dan will take your name. We'll put you live on the air with me. We'll have a great conversation. Trust me, it makes the show much more interesting when you call in. So please do. Anyway, the 9 different ways Florida will have jurisdiction over a non-resident are these. Number 1, operating, conducting, engaging in, or carrying on a business in Florida, or having an office or agency in Florida. So, doing business here. Number 2, and this is where I see it most frequently in what I do day in and day out as a personal injury lawyer. Number 2 is committing a tortious act in Florida. And you may be sitting there saying, okay, what is that? Well, a tort is any kind of a civil wrong. It could be any form of civil negligence, but it doesn't have to be limited to negligence. It can be assault and battery. It could be a tort, could be a murder, even though obviously that contemplates criminal sanctions. A civil lawsuit can be filed because of a murder, and I've done that before. murder-suicide case that I took to trial and got a very large verdict. And have another one right now that we're going to file a lawsuit next week for an incident that happened up in northern Florida. A tort is any kind of a wrong perpetuated against another person or another company. Probably the most common kind of a tort that is perpetuated by a non-resident are car accidents. You have people that come down here that are residents from any other state. I'm not going to suggest that all of our tourists are from New York and New Jersey, but there are a lot of them, and they maintain their residency in their home state of New York and New Jersey. Or if you're on the west coast of Florida, it's often folks from the Midwest, Ohio and all of those states. Well, they come here and not intentionally, but mistakenly and negligently they cause an accident. Well, they go home, and by the time you're ready to file your lawsuit, well, they're back in their home state. And the question is, okay, well, can I sue them in Florida because they caused an accident in Florida? The answer to that question is an emphatic yes, you can, because the statute says that if they commit a tortious act in Florida, you can sue them in Florida. By being here, by being physically present in the state and availing themselves, himself or herself, whoever it may be, to the laws of Florida, which presumably offer them protection for their own sake, by availing themselves to the state of Florida and its laws and protections, they, of course, now have subjected themselves to being sued in the state of Florida. That's the public policy behind the law, but the law simply says if you cause an accident in Florida, you're going to get sued in Florida. Now, that doesn't mean, if you're the plaintiff, that you can't sue that person in their home state of New York, New Jersey, Ohio, whatever their home state may be. You certainly have that option. But chances are, if you're in Florida and if the accident happened in Florida, it's not going to be super convenient for you to file it in some other state. I guess the only time that might be convenient is if you're both here visiting and you're both from the same home state, and for whatever reason you decide to sue them back in your home state. You can do that. Don't be surprised if you do that, the defendant decides to try to move venue down to the state of Florida. Because if that's where all the witnesses are located, if that's where your treatment was obtained, if that's where all the evidence is going to be, then for purposes of convenience, that can be an argument, a legal argument, that they would say, you know what, we want to transfer venue down to Florida because that's where the accident happened. That's something I've never seen, because I've never been asked by a plaintiff in a case to file a lawsuit in some other state. My answer to that would be I can't. I'm only licensed in the state of Florida. Now, I suppose you can petition, and I'm forgetting the Latin term for the petition, but you can file a petition to bring a lawsuit one time in another state using the assistance of co-counsel from that state. If anybody's remembering what that terminology is, please feel free to chime in. But I've never done it. I'm sorry, Dan?
We have 2 minutes.
Oh my, I did it again. I wanted to get to Young versus Love and the dissenting opinion. The trial court went on to observe that on the facts presented, in the context of sexual touching or contact, granting relief to the plaintiff in that case would require the court to impose his or her gender norms. And I say his or her because, remember, this is a case where it was originally born as a male, but she decided she was a female. Her gender norms on unwilling others, which the court declined to do. Basically, the plaintiff filed this lawsuit to say, I want to go to a Black Chippendales show. I was born a male, but I identify as a female, and I want to be in the front row, and I want to be able to touch the dancers and have sexually explicit contact with them, which is all contained in the opinion. It's normal during these shows. And the prevailing opinion said, no, your notions of what is normal are not going to be imposed on others, and we're not going to force them to allow you to touch them if they don't want to be touched by you. The dissenting opinion disagreed, and that's what bothers me. The dissenting opinion said, no, the prevailing opinion has it wrong. When somebody files this kind of a lawsuit because they relate with a different sex, that's a protected class of individual, and we need to protect them. Nonsense, in my opinion. Anyway, thank you very much for listening again. If you want to call me to talk with me privately, dial 833-VASTOLA. That's 833-827-8652. God bless all of you and have a great weekend. Thank you, Dan. Appreciate your help.